Thank you very much. My name is Adewale Atake, SAN, and I think it's only fitting to welcome you to our offices at Templars.
Thank you.
And to wish you a very, very successful deliberation in your meetings. I also want to thank you for giving me the rare privilege of addressing you this afternoon.
Thank you.
When my partner, Godwin Omoaka, SAN, first informed me that as part of hosting this meeting, I'll be addressing the Chartered Institute of Arbitration, I said to myself, what will I be speaking to an esteemed gathering of arbitration practitioners that they don't already know about? And one voice within me said, tell them what they already know. So I'll be speaking to you on the topic you know too well, making Nigeria the preferred seat of international commercial arbitration in Sub-Saharan Africa, the role of CIArb Nigerian branch. Now, the question of making Nigeria the preferred seat for international commercial arbitration in Sub-Saharan Africa is one that is often raised, but is also one that cannot be overemphasized. This is because international commercial arbitration has for years established itself as the dispute resolution mechanism of choice for commercial parties engaged in cross-border transactions. Its key advantages: neutrality, flexibility, party autonomy, and the relative ease of enforcement under the New York Convention makes it uniquely suited to the resolution of disputes arising in international trade and investment. At the heart of international arbitration lies the concept of the seat. The choice of seat, like we all know, determines not only the legal framework governing arbitral process, but also the extent to which courts of that jurisdiction will support or interfere with the arbitral process. For parties negotiating commercial contracts, the seat of arbitration is as important as the governing law of the contract. Nigerians' aspiration to be recognized as the preferred seat of arbitration in Sub-Saharan Africa matters greatly. Not only will it reinforce Nigerians' leadership role on the continent, but it will also enhance investor confidence, deepen the country's integration into global trade and commerce, and contribute significantly to the development of Nigeria's legal service sector. The landscape of arbitration in Nigeria. The Nigerian arbitration landscape has witnessed significant reform, most notably with the enactment of the Arbitration and Mediation Act 2023. The Act represents a long overdue replacement of the Arbitration and Conciliation Act 1988, which has been in force for over 3 decades. The AMA 2023 incorporates modern provisions, including recognition of third-party funding, emergency arbitration, consolidation of proceedings, and express support for mediation, just to mention but a few. These reforms demonstrate Nigeria's seriousness about positioning itself as a viable seat of arbitration. Yet, while the AMA 2023 is a commendable step forward, it is by no means the final word. Arbitration legislation, like the practice itself, is dynamic. Other jurisdictions have shown that constant legislative updates or changes are critical to remain competitive. Nigeria cannot afford another 35 years wait before revisiting its arbitration law. Beyond legislation, arbitral institutions and centers have grown in number across Nigeria. Lagos, in particular, has emerged as a hub of arbitral activity, supported by institutions such as the CIArb, the Lagos Court of Arbitration, and the Lagos Chamber of Commerce International Arbitration Center. While these institutions have recorded successes, Nigeria is not yet at the desired stage. There's a need for consolidation, synergy, and pooling of resources to produce world-class institutions capable of competing with global arbitral centers. The system of arbitration in Nigeria still faces significant challenges, which continue to impede Nigeria's full emergence as a preferred state. These include the perception of judicial interference, delays in the enforcement of arbitral awards, concerns about neutrality, infrastructural limitations, to mention but a few. These challenges require sustained reform, strategic advocacy, and institutional support. The popularity of arbitration as a dispute resolution mechanism has led to intense global competition among jurisdictions to establish themselves as arbitral-friendly seats. Nations have realized that being a preferred seat translates into greater foreign investment, global prestige, economic benefit. Nigeria must understand that it is in competition, not isolation. Even established arbitral seats like London do not rest on their reputations. London remains one of the premier seats of international arbitration, and English law continues to be one of the most frequently selected governing laws for cross-border contracts. Yet, this has not perturbed the United Kingdom from modernizing its legal framework. The recent amendment of the English Arbitration Act 1996 and its replacement with Arbitration Act 2025 is instructive and illustrates a commitment to innovation and relevance. Other major arbitral seats such as Paris, New York, Hong Kong, Singapore, and Dubai have also consolidated their positions through consistent legislative updates, judicial support, strong institutional framework, and international marketing. The attractiveness lies in predictable legal regimes, neutrality, reliable enforcement, globally respected institutions. These are lessons that Nigeria must adopt and implement. Despite the competition, Nigeria possesses unique comparative advantages. Its strategic geographic location as the gateway to West Africa, coupled with its status as Africa's largest economy and most populous nation, gives it natural influence. The country's large commercial markets, expanding investment opportunities mean that many disputes with Nigerian connections are inevitable. Nigeria also boasts a growing pool of legal professionals like yourself with international training and expertise in arbitration. With more practitioners being accredited in international bodies such as the CIArb, Nigeria has human capital to support a world-class arbitration regime. The legislative and judicial framework is also showing signs of positive evolution. AMA 2023 and the increasing pro-arbitration stance of some Nigerian courts reflect an alignment with international best practices. However, gaps remain, and this must be bridged through vigilance and reform. And that's where the CIArb comes in. So in this journey, the CIArb Nigerian branch must play a pivotal role. The branch must not remain a passive observer, but an active driver of reform and institutional strengthening. Its role, I dare say, must include capacity building and accreditation by promoting excellence through structured training, accreditation, and communication education. CIArb Nigeria ensures a steady supply of skilled arbitrators and counsel who can meet global standards. Some of this training have just been rolled out and are quite very, very impressive. Advocacy for best practices. CIArb must continue to push for reforms, whether legislative or institutional, that align Nigeria with international arbitration norms, ethical standards, a consistent emphasis on ethics and professionalism among arbitrators and counsel will enhance confidence in Nigeria's seated arbitrations. Collaboration with other stakeholders. CIArb can foster synergy among arbitral centers, courts, regulators, and the private sector to build a unified framework for arbitration in Nigeria. And I believe that it's already doing that in a very, very impressive manner. International partnership, building partnership with global arbitral bodies, institutions is crucial for Nigeria to project itself as a reliable international standard. I also heard that while the report was being delivered, thought leadership and advocacy. CIArb can actively intervene in critical judicial questions, for instance, in cases currently pending before the Supreme Court, on whether Nigeria can set aside foreign arbitral awards. CIArb could submit amicus brief to ensure pro-arbitration jurisprudence. These recommendations are by no means exhaustive, but I would like to see the CIArb play a more active role as the foremost and leading institution in Nigeria. In conclusion, Nigeria, and particularly Lagos, has potential to emerge as the leading seat of arbitration in Sub-Saharan Africa. The foundations are present: legislative reforms, professional expertise, economic influence, and growing institutional support. However, realizing this potential requires deliberate and coordinated action. CIArb Nigerian branch has a central role in galvanizing stakeholders, driving reforms, promoting ethical practices, and building international confidence. If these steps are taken, Nigeria will not only participate in global arbitration landscape, but will be recognized as a true hub for international commercial arbitration in Africa. Thank you very much for giving me this opportunity to address you. And once again, I wish you a very, very successful deliberation. Thank you very much.